Chapter 2. Significant provisions of the Indian Constitution. Constitution is a dynamic document. It evolves from time to time to reflect the aspiration of the people. To facilitate socio-economic change and national security, it needs to be amended from time to time without hampering the basic structure. During the framing of the Constitution, the provisions related to emergency were included, which stated that the Indian Federation is unique. During the times of emergency, it could connect itself into an entirely unitary system. Introduction to Constitutional Amendment. Constitutional amendment is the modification of the Constitution of a nation. Article 368 of the Indian Constitution deals with the powers of the Parliament to amend the Constitution and its procedures. The procedure for constitutional amendment as contained in Part 20 has certain distinctive features, which mark out Parliament's constituent capacity from its ordinary role as a legislature. However, there is limitation imposed on the amending power of the Parliament of India. There has been disagreement on more than one occasion between the Supreme Court and the Parliament, where Parliament wants to exercise discretionary use of power to amend the Constitution while the Supreme Court wants to restrict that power. This has led to laying down of various doctrines or rules in regards to check the validity, legality of an amendment. The procedure of constitutional amendment is very complex. Steps involved in constitutional amendment. Various steps involved in a constitutional amendment are as follows. Introduction in either House of Parliament. The bill for the amendment of the Constitution can be introduced in either House of the Parliament and not in any state assembly. It can be introduced either by member of ruling party or private member. Constitutional Framework. 31. Both Houses of Parliament must pass it separately. An amendment bill should be passed by both the Houses of Parliament separately. There is no provision for a joint sitting if both houses differ, e.g. In 1970, the Rajya Sabha rejected the 24th Constitutional Amendment Bill, which provided for the derecognition of the princes. Again in 1978, as many as 5 out of 49 clauses of the 45th Constitution Amendment Bill were rejected by the Rajya Sabha. As a result, the Lok Sabha had no alternative, despite of deleting these 5 clauses. Meaning of the majority of total membership. The expression majority of total membership means that it is not the majority of the actual membership of the House. The majority of the total prescribed strengths of the House, notwithstanding the vacancies therein. Special majority at every stage of the passing of the bill. This special majority is needed at the time of final voting on the bill and even on the earlier stages of the bill. The Constitution Amendment Bill, even at its introduction stage, must be supported by a 2/3 road majority of members present in voting, which should not be less than 50% of the total strength of the House. In 1969, the 24th Constitution Amendment Bill regarding abolition of privy purses could not be introduced, because the majority did not support it. It means special majority is needed at the passing of every stage of the bill. Ratification by the legislatures of not less than 1/2 of the states. The amendment of certain articles, mainly which affect the federal structure, must be ratified by 1/2 of the state legislatures by passing resolutions in that respect. The expression state legislature does not include the legislatures of the Union territories. Wherever the state legislature is bicameral, The resolutions must be passed by both houses separately, and the resolutions so passed do not require the signature or the assent of the governor. Presidential assent. In the final stage, the Constitution Amendment Bill is presented to the President for his assent, which the President cannot refuse. But there is no time limit within which the President must give his assent. He can keep it pending for some time in the first instance, though ordinarily it is expected that he would give his assent as soon as possible. Necessity of amending provisions for amendment of the Constitution is made with a view to overcome the difficulties which may be encountered in future in the working of the Constitution. If there had been no provision for the amendment of the Constitution, the people would have recourse to extra-constitutional methods like revolution to change the Constitution. It has been the nature of the amending process itself in federation which has led political scientists' points to classify federal constitution as rigid. A federal constitution is generally rigid in character as the procedure of amendment is usually complicated. The framers of the Indian Constitution were keen to avoid excessive rigidity. They were anxious to have a document which could grow with growing nation, adapt itself to the changing needs and circumstances of growing people. But the framers of Indian Constitution were also aware of the fact that if the Constitution is made very flexible, it would be a play of the ruling party. Hence, they adopted a middle course. It is neither too rigid to admit necessary amendments, nor too flexible for undesirable changes. The Constitution makers have, therefore, kept the balance between the danger of having non-amendable constitution and a constitution which is too easily amendable. Thus, the Indian Federation does not suffer from the faults of rigidity of legalism. Its distinguishing feature is a flexible federation. Types of amendments. Amendments in Constitution are of following types. By simple majority. By simple majority we mean simple majority of the members present and voting, e.g. changes in the names and boundaries of the states, creation or abolition of the legislative councils in the states. Salaries and allowances of the president, governors. (3232). General Studies, Mains, Paper 2. Resolutions to that effect is required before the and judges of the Supreme Court and High Courts etc. can be made by Parliament by passing a law by simple majority. The following provisions of the Constitution fall under this category. Article 100(3) of the Constitution, which fixes quorum of the transaction of business in the Parliament. Article 105 of the Constitution, which deals with powers, privileges and immunities of members of Parliament. Black Circle Article 11 regarding acquisition and termination of citizenship. Article 124, which deals with the appointment of judges in the Supreme Court. Article 135, which deals with conferring more jurisdictions on the Supreme Court. Black Circle Article 81 relating to the delimitation of constituencies. Article 137 of the Constitution, which deals with Supreme Court's powers to review its own judgment. By special majority. Most of the provisions in the Constitution need to be amended by a special majority. It means a majority of not less than 2/3 of the members of that House present and voting, which is more than majority of the total membership of that House. Total membership refers to total number of members comprising the House irrespective of any vacancies or absentees. Special majority is required at all stages of the passage of the Constitution Amendment Bill. The provisions which can be amended by special majority way includes 1. Fundamental rights. Directive Principles of State Policies, DPSPs. Any provision which is not covered in other 2. By special majority of Parliament with ratification by state legislatures. For the amendment of certain other provisions of the Constitution, a bill has to be passed by each House of Parliament by a special majority of the total membership of that House and by a special majority of not less than 2/3 of the members present and voting. Then the amendment must be ratified by the legislatures of not less than 1/2 of the states and by amendment bill is represented to the President for assent. The following provisions of the Constitution fall under this category. Election of the President, Article 57. Extent of the executive power of the Union, Article 73. Extent of the executive power of the state, Article 162. Black Circle Union Judiciary, Chapter 4 of Part 5. High Courts in the States, Chapter 5 of Part 6. Any of the lists in the 7th Schedule. The representation of states in Parliament. Provisions dealing with amendment of the Constitution. Criticism of amendment procedure. Critics have criticized the amendment procedure of the Constitution on the following grounds. There is no provision for a special body like Constitutional Convention, as in USA, or Constitutional Assembly for amending the Constitution. The constituent power is vested in the Parliament and only in few cases in the state legislatures. The power to initiate an amendment to the Constitution lies with the Parliament. Hence, unlike in USA, the state legislatures cannot initiate any bill or proposal for amending the Constitution except in one case, e.g. for passing a resolution requesting the Parliament of the creation or abolition of legislative councils in the states. Major part of the Constitution can be amended by the Parliament alone, either by a special majority or by a simple majority. Only in few cases, the consent of the state legislatures is required, and that too, only half of them, while in USA, it is 3/4 of the states. The Constitution does not prescribe the time frame within which the state legislatures should ratify or reject an amendment submitted to them. Also, it doesn't have provision for the issue whether the states can withdraw their approval. Constitutional FRAMWORK 33. There is no provision for holding a joint sitting of both the Houses of Parliament if there is a deadlock over the passage of a constitutional amendment bill. The provisions relating to the amendment procedure are too sketchy. Hence, they leave a wide scope for taking the matters to the judiciary. Important amendments of the Constitution. First Amendment Act, 1951. The First Amendment of the Constitution of India was enacted in 1951. It made several changes to the fundamental rights and provisions of the Constitution. It provided against abuse of the freedom of speech and expression, validation of zamindari abolition laws, and clarified that the right to equality does not bar the enactment of laws which provide special consideration for weaker sections of society. Accordingly, a new Article 31A was introduced with retrospective effect to uphold such measures. Further, another new Article 31B was introduced to validate 13 enactments relating to zamindari abolition. This amendment set the precedent of amending the Constitution to overcome judicial judgments impeding fulfillment of the government's perceived responsibilities to particular policies and programs. Fifth Amendment Act, 1955. The Fifth Amendment of the Constitution of India 1955 empowered the President to prescribe a time limit for a state legislature to convey its views on proposed central laws relating to the formation of new states and alteration of areas, boundaries or names of existing states. The amendment also permitted the President to extend the prescribed limit and prohibited any such bill from being introduced in Parliament until after the expiry of the prescribed or extended period. The Fifth Amendment re-enacted the provision to Article 3 of the Constitution. 11th Amendment Act, 1961. The 11th Amendment of the Constitution of India, 1961, provided that the Vice President shall be elected by the members of an electoral college consisting of the members of both houses of Parliament, thereby dispensing with the earlier requirement of a joint meeting of members of both houses of Parliament assembled for the said purpose. The 11th Amendment inserted a new clause, 4, in Article 71 of the Constitution to clarify that the election of President or Vice President cannot be challenged on the ground of the existence of any vacancy for whatever reason in the appropriate electoral college. 15th Constitutional Amendment Act, 1963. The 15th Amendment of the Constitution of India, 1963, enabled the High Courts to issue writs to any person or authority even outside its territorial jurisdiction if the cause of action arise within its territorial limits. It increased the retirement age of the High Court's judges from 60 to 62. It provided for the appointment of retired judges of the High Courts as acting judges of the same court as well as the ad hoc judges of the Supreme Court. 42nd Amendment Act, 1976. The 42nd Amendment of the Constitution of India, 1976, was enacted during the emergency, 1975 to 1977. This amendment is regarded as the most controversial constitutional amendment in Indian history. It attempted to reduce the power of the Supreme Court and High Courts to pronounce upon the constitutional validity of laws. It laid down the fundamental duties of Indian citizens to the nation. This amendment brought about the most widespread changes to the Constitution in its history and is sometimes called a mini-constitution. The amendment established supremacy of Parliament over the other wings of government, gave the directive principles precedence over the fundamental rights, enumerated for the first time a set of 10 fundamental duties. The Act also clearly laid down that no constitutional amendment could be questioned in any court of law. The 42nd Amendment also amended the preamble and changed the characterization of India from sovereign democratic republic to a sovereign, socialist secular democratic republic, and also changed the words unity of the nation to unity and integrity of the nation. It further imposed limits on the power and jurisdiction of the judiciary, raised the term of the Lok Sabha and the Vidhan Sabha from 5 to 6 years, authorized the use of central armed (34). General Studies, Mains, Paper 2. Forces in any state to deal with law and order problems. It authorized the President to proclaim emergency in any part of the country. 44th Amendment Act, 1978. The 44th Amendment of the Constitution of India was enacted by the Janata Party government. The Act removed major distortions in the Constitution, introduced by 42nd Amendment Act. The duration of the Lok Sabha and state legislative assemblies were reduced back from 6 to 5 years. The right to property ceased to be a fundamental right and became only a legal right. The act also extended constitutional protection for publication of the proceedings of Parliament and state legislatures, except in cases where it is proved to be malicious. Another important feature of the act was that any proclamation of emergency needs to be issued by the President only after receiving the advice of the Cabinet as a whole in writing. The President will not be called upon to act on the basis of advice by the Prime Minister on his own without consulting his Cabinet. Other safeguards provide that the proclamation will have to be adopted by a 2/3 road majority of the members of Houses of Parliament within a month and thereafter periodic control of Lok Sabha. The 44th Amendment provided safeguards against future subversion of the Constitution for establishing an authoritarian regime. 69th Amendment Act, 1991. This amendment added 2 new articles, 239AA and 239AB to the Constitution. Article 239A provides for the establishment of Legislative Assembly and Council of Ministers for the National Capital of Delhi. The administrator for the NCT of Delhi will be designated as the Lieutenant Governor. The number of seats and all matters relating to the functioning of the Assembly shall be regulated by law made by Parliament. The Legislative Assembly shall have power to make laws for the NCT of Delhi with respect to any matters enumerated in the state list or in the concurrent list. However, Parliament shall have overriding powers with respect to any matters for a union territory. In case of difference of opinion between the Lieutenant Governor and the Council of Ministers, the Lieutenant Government shall refer it to the President and shall act according to the decision given by the President. The new Article 239AB provides for the imposition of the President rule in the case of failure of constitutional machinery in the NCT. 73rd Amendment Act, 1992. This amendment added a new Part 9 to the Constitution consisting 16 articles and new Schedule 11. These articles provide for the constitution, composition, election, duration and powers and responsibilities and power to levy taxes and duties by the Panchayati Raj institutions in the rural areas. 74th Amendment Act, 1992. This amendment added a new Part 9A to the Constitution relating to urban local bodies, which consists of 18 articles and a new Schedule, 12th Schedule. These articles provide for the constitution, composition, election, duration of municipalities and power and responsibilities upon municipalities in respect of preparation of plans for economic development and levy taxes and duties by municipalities. 86th Amendment Act, 2002. This Amendment Act added a new Article 21A after Article 21, which makes the right of education of children of the age of 6 to 14 years a fundamental right. It also substitutes Article 45, which is as follows: the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. It has also added a new fundamental duty to Part 4 of the Constitution. 91st Amendment Act, 2003. This amendment has added 2 new clauses, 1A and 1B, to Article 75 and Article 164 of the Constitution. According to new clause 1A, the total number of ministers including the Prime Minister in the Central Council of Ministers shall not exceed 15% of the total members of the Lok Sabha. The new clause 1B of Article 75 provides that a member of the either House of Parliament belonging to any political party who is disqualified for being member of that House on the ground of defection, shall also be disqualified to be appointed as a minister under Clause 1 of Articles 75 and 164 until he is again elected. Constitutional FRAMWORK 35. 92nd Amendment Act, 2003. It has amended the 8th Schedule to the Constitution and has inserted 4 new languages in it, viz. Bodo, Dogri, Maithili and Santalt. After this amendment, the total number of constitutionally recognized official languages has now become 22. 94th Amendment Act, 2006. This amendment freed state of Bihar from the obligation of having a tribal welfare minister and extended the same provision to Jharkhand and Chhattisgarh. This provision will now be applicable to the 2 newly formed states in Madhya Pradesh and Odisha, where it has already been in force. Article 164, 1. 97th Amendment Act, 2011. The 97th Amendment of the Constitution of India, 2011, was a major legislation for the expansion of scope of cooperative societies in India. It added the words "or cooperative societies" after the word "or unions" in Article 19, 1c, and inserted the Article 43b, la promotion of cooperative societies, and added Part 9 Bila, the cooperative societies. The new Articles 243, ZH to 243, ZT were exclusively added to this Part 9b. The amendment objective is to encourage economic activities of cooperatives, which in turn help progress of rural India. It is expected to not only ensure autonomous and democratic functioning of cooperatives, but also the accountability of the management to the members and other stakeholders. 100th Constitutional Amendment, 2015. Under this amendment, the India-Bangladesh Agreement was signed in 1974. But it was not ratified as it involved transfer of territory, which required a constitutional amendment. This enabled the 2 countries to exchange lands known as enclaves or chitmahal in each other's territory. According to the amendment, India received 51 Bangladeshi enclaves, covering 7,110 acres, in the Indian mainland, while Bangladesh received 111 Indian enclaves, covering 17,160 acres, in the Bangladeshi mainland. The agreement also settles the question of citizenship for over 50,000 people. The enclave residents could continue to reside at their present location or move to the country of their choice. 101st Constitutional Amendment Act, 2016. It conferred simultaneous power upon Parliament and state legislature to make laws governing GST, good and service tax. It subsumes central and state taxes under GST. This act levy of IGST on interstate transactions of goods and services. This act applies GST on all goods and services except alcoholic liquor. Petroleum and petroleum products shall be subjected to the levy of GST on a later date as decided by the GST Council. GST Council, a constitutional body, created with 2/3 road representation from states and 1/3 road from center, to examine issues related to GST and make recommendation on rates, taxes, cesses, surcharges, exemption list, dispute resolution, etc. All decisions in GST Council to be taken by 3/4. It will function under the chairmanship of Union Finance Minister. This act provides compensation to states for the entire amount of revenue losses for 5 years. Emergency provisions in Indian Constitution. One of the chief characteristics of the Indian Constitution is the way in which the normal federal constitution can be adapted to emergency situation. It is the merit of the Constitution that it visualizes the circumstances when the strict application of the federal principles might destroy the basic assumptions on which our Constitution is built. The Constitution of India provides three types of emergency. 1. National emergency, Article 352, due to war, external aggression or armed rebellion. 2. State emergency, Article 356, due to the failure of constitutional machinery in states. 3. Financial emergency, Article 360. 1. National emergency, Article 352. Article 352 provides that if the President is satisfied that a grave emergency exists whereby the security of India or any part of India is threatened, either by war or external aggression or armed rebellion, he may make a proclamation of emergency in respect of the whole of India or any part of India as may be specified in the proclamation. The proclamation of emergency made may be varied or revoked by the President by a subsequent proclamation. (36) The President shall not issue a proclamation unless the decision of the Union Cabinet that such a proclamation may be issued has been communicated to him in writing. This means that the emergency can be declared only on concurrence of the Cabinet and not merely on the advice of the Prime Minister. This provision is inserted by 44th Amendment Act. A proclamation of emergency can be made even before the actual occurrence of event contemplated in Article 352 have taken place if the President is satisfied that there is imminent danger of war or external aggression or armed rebellion. Parliament's control. The proclamation of emergency must be laid before each House of the Parliament, and it shall cease to be in operation at the expiration of 1 month, unless before the expiry of 1 month it has been approved by resolutions of both Houses of the Parliament. If the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month referred to above, without approving the proclamation, but the proclamation has been approved by the Rajya Sabha, the proclamation shall cease to operate at the expiration of 30 days from the date on which the Lok Sabha sits after election, unless before the expiry of the above period of 30 days a resolution approving the proclamation has been passed by the Lok Sabha. A resolution approving the proclamation must be passed by special majority, that is by a majority of the total members of each House and also by a majority of not less than 2/3 vote of the members present and voting in each House. Prior to the 44th Amendment, such resolution could be passed by the Parliament by a simple majority. A proclamation of emergency once approved by Parliament shall remain in force for a period of 6 months from the date of the passing of the second resolution approving it, unless revoked earlier. For the further continuance of the emergency beyond the period of 6 months, approval by Parliament would be required every 6 months. If the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency. General Studies, Mains, Paper 2. But it has been approved by the Rajya Sabha, the proclamation shall cease to operate at the expiry of 30 days after the Lok Sabha's fresh reconstitution unless before the expiry of the above period, it is approved by the Lok Sabha. The power conferred on the President by this article shall include the power to issue different proclamations on different grounds, either war or external aggression or armed rebellion or imminent danger thereof, whether or not there is a proclamation already issued by the President and such proclamation is in operation. Effects of Proclamation of Emergency. The following are the effects of the Proclamation of Emergency. 1. Extension of Center's executive power. Article 353. During the operation of a proclamation of emergency, the executive power of the Union extends to giving of directions to any state as to the manner in which the executive power of the state is to be exercised. The 42nd Amendment made a consequential change in Article 353 following the amendment made in Article 352. It provides that the executive power of the Union to give directions under Clause A, and the power to make laws under Clause B, shall also extend to any state other than the state where emergency is in force, if the security of India or any part of the territory is threatened by activities in or in relation to that part of the territory of India in which the proclamation of emergency is in operation. Parliament empowered to legislate on state subjects. Article 353, b. While the proclamation of emergency is in operation, the Union Parliament is empowered to make laws with respect to any of the matters in the state list. The distribution of legislative powers is thus fundamentally changed during emergency. The lawmaking power of the state is not suspended during the emergency. The state can make laws, but it is subject to the overriding power of the Union Parliament. Extension of life of Lok Sabha, Article 83, 2. While the proclamation of emergency is in operation, the President may extend the normal Constitutional FRAMWORK 37. Life of the Lok Sabha by a year each time up to a period not exceeding beyond 6 months after proclamation ceases to operate. Suspension of Fundamental Rights. Article 358 and Article 359 deals with the suspension of fundamental rights except Article 20 and Article 21. These two can be discussed as follows. 1. Article 358 states that when a proclamation of national emergency is made, the 6 fundamental rights, under Article 19, are automatically suspended and no separate notifications are required for the same. However, this will happen only when the national emergency is declared on the ground of war or external aggression. It also states that the state can make any law or take any executive actions abridging the 6 fundamental rights under Article 19. When the national emergency ceases to operate, Article 19 automatically revives and comes into force. However, no remedy lies for any executive action taken related with emergency after the emergency expires. 2. According to Article 359, the President can suspend the right to move any court for the enforcement of fundamental rights except under Article 20 and Article 21. This suspension could be for the period during the operation of emergency or for the shorter period as mentioned in the order. When the emergency ceases to operate, this suspension also gets terminated and those laws which are related with the emergency are protected from being challenged. Amendments affecting emergency provisions in tense politics during 1970s gave rise to 3 substantial amendments within a span of 3 years OIS of this national emergency. These can be discussed as follows. 1. 38th Constitutional Amendment Act, 1975, it empowered the president to proclaim national emergency on different grounds even though an emergency is already under suspension. 2. 42nd Constitutional Amendment Act, 1976. It empowered the president to modify or vary national emergency. Under the original Constitution, only the imposition or revocations were possible. Under the original Constitution, the president could have imposed national emergency only over complete territory of India. This amendment enabled him place to impose it on over part of the country. 3. 44th Constitutional Amendment Act, 1978. It was enacted to prevent the misuse of emergency power by the executive. Previously, the president could have declared emergency on the grounds of war, external aggression and internal disturbances. As internal disturbance is a vague term, which is prone to misuse, it was replaced with a more precise term, armed rebellion. The original Constitution did not provide any modality for tendering an advice to the president regarding the proclamation of emergency, because of which, even an oral advice by Prime Minister would have been sufficient to proclaim emergency. After 44th Amendment, a written advice of the Cabinet is mandatory for the President to proclaim national emergency. Previously, a simple majority was only required to ratify an emergency proclamation, which was replaced by special majority. Previously, once Parliament approves national emergency, it continued to operate till the President revoked it. After 44th Amendment, periodic parliamentary control was ensured. 44th Amendment also ensured continuous control of Lok Sabha over the operation of national emergency. Previously, when the President declared emergency on the grounds of war, external aggression and internal disturbances, fundamental rights enjoyed under Article 19 used to get automatically suspended. After 44th Amendment, this automatic suspension doesn't happen if emergency is proclaimed on the ground of armed rebellion. Previously, the President could have suspended any or all fundamental rights during the operation of national emergency. After 44th Amendment, the President can suspend operation of all fundamental rights except Article 20 and Article 21. '38. General Studies, Mains, Paper 2. 2. State Emergency, Article 356. Article 356 says that if the President, on receipt of a report from the governor of a state or otherwise is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, he may issue a proclamation. By that proclamation, the President may assume to himself all or any of the powers vested in or exercised by the governor or any body or authority in the state. The President may declare that the powers of the legislature of the state be exercised by or under the authority of Parliament. The President may make such incidental and consequential provision as may appear to him to be necessary or desirable for giving effect to the object of proclamation. The President cannot, however, assume to himself any of the powers vested in High Court or suspend the operation of any provisions of the Constitution relating to the High Court. When the proclamation of emergency is made under Article 356, 1. The powers of the state legislature are to be exercised by Parliament. Parliament can confer on the President the power to make laws for the states. Parliament may also authorize the President to delegate such power to Lok Sabha as not in session. The President may authorize expenditure from the consolidated fund of the state, pending sanction of such expenditure by Parliament. The proclamation issued under Article 356, 1, may be revoked or varied by the President by a subsequent proclamation. In view of Center's ultimate responsibility to protect the constitutional machinery of the states, the framers of the Constitution thought that it is not proper to confine the action of the Center merely on the governor's report. The governor might not sometimes make a report. The president can, therefore, act even without the governor's report, if he is satisfied that such events have occurred in a state which require the center to maintain the state under the Constitution. Parliament's control in state emergency. A proclamation issued under Article 356 shall be laid before each House of Parliament and shall remain in operation for 2 months unless before the expiry of that period it has been approved by both Houses of Parliament. Any such proclamation may be revoked or varied by a subsequent proclamation. If any such proclamation is issued at the time when Lok Sabha is dissolved or the dissolution takes place during the period of 2 months and the proclamation is passed by the Rajya Sabha, but not passed by the Lok Sabha, the proclamation shall cease to operate at the expiry of 30 days from the date on which the new Lok Sabha meets after the reconstruction unless before the expiry of 30 days, it has been also passed by the Lok Sabha. If the proclamation is approved by the Parliament, it will remain in operation for 6 months. Parliament may extend the duration of proclamation for 6 months at a time, but no such proclamation shall in any case remain in force for more than 3 years. After the expiry of the maximum period of 3 years, neither Parliament nor the President shall have power to continue a proclamation, and the constitutional machinery must be restored to the state. Effects of state emergency. On executive, state government is dismissed and or dissolved. The executive power of the state is exercised by the center. On legislature, state legislature does not function to any other authority as specified by himself. If the state legislative assembly is either suspended. On financial relations, there is no impact on the distribution of financial resources between center and the state. Amendments associated with state emergency. Various controversial and intense politicization led to fast amendments in 1970s, which are stated below. 1. 42nd Amendment Act, 1976 extended the period of state emergency from 6 months to 1 year. 2. 44th Amendment Act, 1978 reverted back the operation of state emergency to 6 months. Further, it divided the maximum period of 3 years of operation into 1 year under ordinary circumstances and 2 years under extraordinary. Constitutional Framework. 39. Circumstances, for which the following stipulated conditions shall have to be satisfied. 4. A proclamation of national emergency should be in operation in any part of the country. 10. Election Commission shall certify that elections are not possible to conduct in the state. Judicial Review of State Emergency. S.R. Baumai Case, 1994. The susceptibility of a proclamation under Article 356 to judicial review is beyond dispute because the power under Article 356(1)(15) a conditional power. In the exercise of the power of judicial review, the court is entitled to examine whether the condition has been satisfied or not. So, the controversy actually revolves around the scope and reach of judicial review. From the decisions in the case of State of Rajasthan US Union of India and the Bommai case, it is clear that there cannot be a uniform mile applicable to all cases. It is bound to vary depending upon the subject matter, nature of the right and other factors. However, where it is possible, the existence of satisfaction can always be challenged on the ground that it is mala fides or based on wholly extraneous and irrelevant grounds. S.R. Bommai's Union of India was a landmark in the history of the Indian Constitution. The Supreme Court said that Article 356 is an extreme power and is to be used as a last resort in cases where it is manifested that the machinery in a state has collapsed. The views expressed by the court in this case are similar to the concerns shown by the Sarkaria Commission. Thus, we can safely conclude that the presidential proclamation under Article 356 is subject to judicial review. The Supreme Court in this case has laid down certain guidelines so as to prevent the misuse of Article 356 of the Constitution. 1. The majority enjoyed by the Council of Ministers shall be tested on the floor of the House. 2. Center should give a warning to the state in a time period of 1 week to reply. 3. The court cannot question the advice tendered by the Coms to the President, but it can question the material behind the satisfaction of the President. Hence, judicial review will involve 3 questions only. A. Is there any material behind the proclamation? B. Is the material relevant? C. Was there any mala fide use of power? 4. If there is improper use of Article 356, then the court will provide remedy. 5. Under Article 356(3), it is the limitation on the powers of the President. Hence, the President shall not take any irreversible action until the proclamation is approved by the Parliament. He shall not dissolve the Assembly. 6. Article 356 is justified only when there is a breakdown of constitutional machinery and not administrative machinery. 7. Article 356 shall be used sparingly by the center. Otherwise it is likely to destroy the constitutional structure between the center and the states. Even Dr. Ambedkar envisaged it to remain a dead letter in the Constitution. This judgment gave back the autonomy to the states and protected the federal nature which forms the basic structure of the Indian Constitution. Observations of relevant commissions with respect to Article 356. Sarkaria Commission, 1987. Article 356 should be used very sparingly, in extreme cases and only as a matter of last resort. The Commission also recommended that any imposition of Article 356 should be accompanied with a report by Governor to the President with relevant facts and details. No dissolution of Assembly till proclamation is ratified by the Parliament. National Commission for Reviewing the Working of Constitution, 2002. A warning should be issued to the errant state in specific terms, that it is not carrying on the government of the state in accordance with the Constitution. Before taking action under Article 356, any explanation received from the state should be taken into account. The state legislative assembly should not be dissolved either by the governor or the president before the proclamation issued under Article 1040. General Studies, Mains, Paper 2. 356(1) has been laid before Parliament and it has had an opportunity to consider it. Article 356 should be suitably amended to ensure this. The Governor's report, on the basis of which a proclamation under Article 356(1) is issued, should be given wide publicity in all the media and in full. Safeguards corresponding to that of Article 352 should be incorporated in Article 356 to enable Parliament to review continuance in force of a proclamation. Punchy Commission, 2008. The Commission recommended imposition of localized emergency 1(e). Only a district or a part of a district to be brought under governor's rule instead of the entire state. Such an imposition should not be of a duration exceeding 3 months. It also recommended suitable amendments be made in Article 356 to incorporate the guidelines of Supreme Court in S.R. Baumai case, 1994, with regards to invoking of the article. Difference between Article 352 and 356. Under Article 352, the state constitution cannot be suspended. The state legislature and the state executive continue to function. The only effect is that center gets concurrent power of legislation and administration in state matters. Under Article 356, on the other hand, the state legislature is suspended and dissolved. The executive and legislative power of the state is exercised by the center. Under Article 352, the relationship of all the states with the center undergoes a change, while under Article 356 the relationship of only the concerned state with the concerned center is affected. 3. Financial emergency, Article 360. Article 360 provides that if the President is satisfied that situation has arisen whereby the financial stability or credit of India or part of the territory is threatened, he may make proclamation to that effect. The 44th Amendment makes Article 360 self-contained. It provides that the proclamation of financial emergency shall cease to be in operation at the expiry of 2 months unless it has been approved by both the Houses of Parliament by simple majority. Parliament's control. Such a proclamation may be revoked or varied by the President by a subsequent proclamation. But if the Lok Sabha is dissolved during the period of 2 months and resolution is approved by the Rajya Sabha but not by the Lok Sabha, the proclamation shall cease to operate at the expiry of 30 days from the date on which the new Lok Sabha sits unless before the expiry of 30 days a resolution approving proclamation is passed by the Lok Sabha. Effects of financial emergency during the period when emergency is in operation. The executive authority of the Union shall extend to give directions to any state. These directions are for to observe such canons of financial propriety as may be specified in the directions and be deemed necessary by the President for maintaining financial stability and the credit of the state. Any such direction may include a provision for the reduction of salaries and allowances of all or any class of persons serving in a state, including the judges of the Supreme Court and High Courts. It may also require that all money or financial bills are to be reserved for the consideration of the President after they are passed by the legislatures of the state. Criticism of the emergency provisions. Indian Constitution was formed to envision India as a liberal state based on benign articles. However, provisions of emergency contradict such vision of the Constituent Assembly as evident from the following. 1. Union's authoritative power will rise manifold, diluting the concept of federation. 2. Almost all of the power will be concentrated into President. 3. Fundamental rights, as a very foundation of democracy, will have no sanctity. 4. State will simply be the center's subordinate in all aspects. However, such provisions have been termed as safety valve or long arm of the center. Its existence lied to uphold and encourage the ideals of nation. Even being highly skeptic, these provisions were added to deal with extraordinary situations.